Speak not just a mature compassion, but also a recognition that the past is always with us. And indeed, as William Faulkner reminds us in his 1950 Nobel address, the past is not even past. And we as a nation are who we are, in large part because of who we once were. And we can be proud. One reason why we can be exceptionally proud of who we are is because of who we once were. A nation that divided its own citizens according to race. Root and Branch explores how two attorneys devised and executed legal strategy that chipped away at the doctrine of separate but equal, that chipped away at legal segregation here in America. In 1935, the most famous black lawyer in America was Charles Hamilton Houston. And he was famous because he had defended a black man accused of murdering two white women in rural Virginia. Mr. Houston had graduated from Amherst College at the age of 19, entered the Army for World War I, and graduated from Harvard Law School, and was the first African American to serve on the Harvard Law Review. He also earned a very rare degree, a doctorate of judicial science from Harvard Law School. He was the dean of Howard University and effected a revolution at Howard. But he then was hired away by the NAACP to be their first attorney. In 1935, he was charged by Walter White, who was the executive secretary of the NAACP. He was charged with devising a strategy to end segregation in transportation and in education. And Mr. Houston looked and saw the money that was budgeted for the campaign and said, you need to pick one or the other. So they chose education. And he came up with a strategy of how to do it. And the strategy is brilliant in its simplicity. And I'd just like to read a paragraph here that describes the strategy. And the strategy is so, as I said, it's so wonderful in its simplicity that it can be summarized very quickly. While often heralded as a reversal of long-standing jurisprudence, the Supreme Court's decision in the cases gathered as Brown versus Board of Education was in fact an extension of the court's earlier decisions. Brown expanded existing law, and the ship launched by Charles Houston 20 years earlier at last reached uncharted shores. In 1935, however, the wind blew steadily in the opposite direction. Separate but equal schools and buildings were constitutionally permissible under the Supreme Court's Plessy versus Ferguson decision. To challenge Plessy to set sail into the wind would be the errand of a doomed fool. So when Walter White asked Houston to present a plan by which the NAACP could launch a sustained legal campaign to end segregation, Houston charted a novel course. To defeat the law of separate but equal, he would argue for the enforcement of separate but equal. In southern states, he would argue that segregation's mandate needed to be met. He would seek to end segregation's scourge by arguing for the fulfillment of its promise. This is what he did. He said, the Supreme Court says you can separate Americans by race so long as you have separate and equal facilities. We're going to start in schools. We're going to start in colleges, not deal with people's children because that gets too much ire. It gets everyone's ire up. And we're going to start in law schools. Why? Because every judge went to law school. He convinced the NAACP to hire his favorite student from Howard Law School, Thurgood Marshall, and they set course. They started at the University of Maryland Law School, where Marshall had wanted to attend but did not apply because the University of Maryland did not accept black students. So they had a young man, Donald Murray, who was a graduate of Amherst College and the scion of a prominent Baltimore family, and he wanted to attend the University of Maryland Law School. They sued them, the case went to trial. It was deemed so hopeless, something of a farce even, that someone would try to sue to get a black man into the University of Maryland, that nobody showed up to watch the trial except Thurgood Marshall's dad, who would have been there if it had been a hit-and-run accident trial. the question that Houston and Marshall that they asked the witnesses for the University of Maryland, very simple. Does the state of Maryland have a law school for white students? Yes. What is it? The University of Maryland. Does the state of Maryland have a law school for black students? No. Thank you very much. The argument was because Maryland does not even have a separate law school for black students. So we don't even reach the question of whether it's equal. And unless and until Maryland builds a law school for its black students, there is no choice. The Plessy versus Ferguson, separate but equal, demands that you allow the black students to go to the white school. So we're not asking you to overturn Plessy. We understand that's the law of the land, Your Honor, but because Maryland's not living up to separate but equal, you have to let them in. So we're not integrating the school. There's just no separate place for us to go. And the judge shocked everybody, including Houston and Marshall, by agreeing and issuing a ruling from the bench in order that Donald Murray be accepted into the University of Maryland Law School. The case went through the appellate process in Maryland State Court, but the NAACP prevailed, and Donald Murray graduated from the University of Maryland 3 years later and had a very long and successful career practicing law in Maryland. This was such a watershed event. Black folks nationwide went crazy. They could not believe it. And it was like, wow, we are going to get rid of this segregation stuff by suing in the courts. This is fantastic. And Houston said, slow down. We can't get too excited yet. He published a piece in the NAACP magazine, The Crisis, called Don't Shout Too Soon. And he said, we have a long way to go. We're just starting here. So shout if you want to, but don't shout too soon. He knew the road would be long, and he knew that the Maryland case was only law in Maryland. They did not yet have federal precedent. They found it a few years later in Missouri. In Missouri, similar situation. Lloyd Gaines, who was a very gifted young man, and he applied to the University of Missouri Law School, wanted to go there. They didn't let him go because he was African American. Sued. This case, though, was in federal court, and this case went to the Supreme Court of the United States. For the first time, they were able to test that strategy of enforcing separate but equal. They said it's clear in the record that Missouri admits they have no law school for their black students. So in order to enforce Plessy versus Ferguson, in order to enforce your own ruling to the high court, you must admit this man to the University of Missouri Law School. It's not integrating the school. It's just enforcing what you've already written, that there has to be a separate and equal law school. And there isn't one here. They admit, the state of Missouri admits that there is not a separate and equal law school. So the court agreed and said that Missouri was not living up to the mandate set down in Plessy versus Ferguson. And Lloyd Gaines was ordered admitted to the University of Missouri Law School. So these cases went on, and there are several more, but when we fast forward, we get to 1948 and 1950, and Oklahoma was not having any of this stuff. The state of Oklahoma said, we don't care what the Supreme Court of the United States says, we do not allow Negroes in our law school, and that's that. The young woman applied, Ada Lois Seafield applied to the University of Oklahoma, and she was denied. And they went back to the Supreme Court of the United States, and at this point, the court was getting irritated. The Washington Post described it as a hazing. They said the justices inflicted a hazing upon the counsel for the University of Oklahoma, saying, why are you even here? We told you 10 years ago that you have to allow Negroes to attend the university unless and until you are willing to build an equal school for them. And you're not. And yet this young woman has to come here in order to go to law school. Oklahoma admitted her based on a unanimous Supreme Court decision, but they made her sit in the back of the classroom beneath the banner that said colored student section, and she could only eat at one table in the dining hall that said colored student section, and there was only one table in the library that she could sit at, the colored student section. It was noxious behavior, but it was exactly what the NAACP needed to take that next step. In 1950, they had two cases, one in Oklahoma and one in Texas. And now when you have someone who's seated in the classroom, they had George McLaurin, who was the plaintiff, 68-year-old man, attending graduate school at the University of Oklahoma, and he had to sit beneath this banner that said colored student section. But see, what we have now is he's in the same classroom as the white students. He's hearing the same lecture, able to take whatever notes he wants to take, but he has to sit beneath this banner. Now we hit the question of segregation itself. He's right there in the class. He's not in a separate room, he's not in a separate building, but he has his badge. It's right there everywhere he goes. When he goes to eat, he can only eat there. When he goes to study, he can only study there. And he said, on the record, he said, it's humiliating. And it makes it difficult for me to study. So they started moving to the intangibles. The court unanimously held in 1950 that the University of Oklahoma had to take down the banner. The man could sit wherever he wanted to sit, eat where he wanted to eat, and study where he wanted to study at the University of Oklahoma, because he could not be expected to do his best if he has to sit beneath this banner above his chair, his desk, that says colored student section. That's 1950. That is the point where Brown became possible. Because think of the corner that Marshall and Houston had painted the justices into. If the Constitution does not allow a grown man to sit in the same classroom with white students, but he can only sit over there, how can the Constitution allow thousands of children to be forced to sit in another building on account of their race? It cannot forbid one, which the court said the Constitution forbids this grown man from having to sit in a specific chair on account of his race. The Constitution cannot forbid that and allow these children to be forced to sit in a whole separate building. So Brown, at that point, became something of an inevitability. The unanimity of the decision, the 9-0 decision itself, still stands as something of a judicial miracle. But the decision of Brown versus Board of Education, those 5 cases that were consolidated as Brown, the groundwork for that was laid over a period of years through cases. What I'd like to leave you with is what I was left with after 4 years of researching and writing this book, and that is that we hear a great deal of talk, particularly in the last 10 years, about activist judges. The phrase is used so often by those on the right and the left that it's almost devoid of meaning at this point. At this point, an activist judge is a judge whose opinion you happen not to like. And indeed, on some occasions, the course of this nation's history has been changed by activist judges. But every single time, the course of this nation's history has been changed by activist citizens. And oftentimes, those citizens are working with activist lawyers. The 35 of the 55 founding fathers were activist lawyers who were so fed up with the conditions under which they were forced to live that they founded a new nation. So it's activist citizens like Heman Sweat, like Ada Loisipu, like Lloyd Gaines. These are the Americans who helped make our country great, in part because they believed in their country more than their country believed in them. And working with Houston and working with Marshall, both members of Alpha Phi Alpha Fraternity Incorporated, they defeated staggering odds. They won against staggering odds. So when I hear this talk about activist judges, sometimes I just think it's giving the judges a little too much credit. There's an airport named after Thurgood Marshall in Baltimore, and there are numerous schools named after Charlie Houston. But the true monuments of their labor are the lives that you and I are able to lead each day. Because each day that we can gather, as we do on this campus, each day that we can come together under one roof, regardless of our race, regardless of our religion, regardless of our gender, each one of those days that we're able to do that, each one is both a testament and a celebration of the battles fought and won by Charles Houston and Thurgood Marshall. Thank you.